Contesting a trust in California is quite common. We're here to help beneficiaries and heirs determine whether they should pursue a contest and what the likely outcome might be. Contesting a trust, disputing a trust, voiding a trust, invalidating a trust are all common terms for the legal process in which a beneficiary or heir seeks to change the inheritance, gift, bequest, or distribution they're set to receive per a trust agreement after a loved one passes away. Yes, anyone can contest a trust, and it's more common than people think. Trust contests often hinge on the ability to prove that the person who created the trust lacked capacity to do so, often because of a stroke, dementia, or other condition, or the person was subjected to undue influence by someone who benefited from having exerted that influence over them. Yes, we protect families and heirs every day. In many cases, one beneficiary will contest a trust for the benefit of multiple heirs, beneficiaries, or family members. We work with heirs and families to resolve trust disputes quickly, efficiently, and cost-effectively, often for the benefit of multiple parties. Yes, most contestants are beneficiaries to the trust who have had their inheritance reduced due to the undue influence of an interloper. First, consult an experienced trust contest attorney who can help you examine the facts of your case and advise whether your case is worth pursuing, both from an emotional and a financial standpoint. Second, file a petition with the county court in which the trust is being administered, usually where the trustee is. Third, make sure your contest is timely filed. In most instances, the trustee will have sent a notice of irrevocability under Probate Code Section 16061.7, which will set hard deadlines by which you need to have your trust contest filed in the court. If you miss that deadline, you likely will be barred from pursuing your claim at all. Fourth, rely on your counsel to investigate the sources of additional information and witnesses who can provide evidence needed to secure a favorable result in your case. Fifth, when you have the information you need, you're ready to mediate, which just means try and settle your case, or take it to trial. Some common legal claims that form the bases of most trust contests include incapacity or lack of legal capacity simply means that the person who created the trust may have been incapacitated. For example, they were in a coma, they had had a stroke, or they otherwise lacked mental capacity sufficient to have understood what they were doing. And here we're thinking about Alzheimer's dementia, the result of medications that have them not at their best. And they have to be suffering from this when they executed the trust at issue. Undue influence or coercion arises when the trust doesn't represent the decedent's true intended disposition of his or her estate, because someone else exercised undue influence over them and coerced them to provide benefits to them that they otherwise would not have given them if they had done it of their own free will. Very often, the coercing party is a family member who cared for the decedent, a caregiver, a friend, but often it can be anyone who is providing any service to the decedent who has an opportunity to unduly influence them and obtain an unintended benefit. Trust fraud, including document forgery, results when documents are simply forged or doctored. This can also open the door to criminal charges, but most of these issues are resolved in the civil courts, specifically the probate court. You may have been told that you have 120 days to contest a trust. While it's possible that you could have only 120 days from your loved one's passing, the deadline is going to be set by that 16061.7 probate code notice that is issued to you. Probate Code 16061.7 gives an heir or beneficiary 120 days from the date notice is mailed to file your contest. If the notice does not contain a copy of the trust, then you will need to ask for a copy. If no copy is provided, then you still have the original 120 days to file your contest. If a copy is provided within the 120 days, then you have 60 days from the date the trust is mailed to you to file your contest. It's a very confusing area and it's easy to get this wrong. You would be best served to retain counsel to help you examine your deadline as soon as you have an inkling that you may want to file a contest, even if it's before you get a copy of the trust. The vast majority of states do not enforce no contest clauses, sometimes called in terrorem clauses. clauses. California is one of the few exceptions, albeit in limited circumstances. The main things to remember are: 1, if you have probable cause to contest the trust, then the no contest clause most likely will not be enforced against you. And 2, if your gift was eliminated, rendering the no contest clause irrelevant, you have nothing to lose and can contest without worrying that the clause will even come into play. In general, we recommend working with a trust litigation lawyer familiar with the county probate court in which the trust is being contested, which again is where the trustee usually is. For example, if the decedent lived in Los Angeles and the trust is being administered by a trustee in Los Angeles, we recommend working with a trust litigation attorney in Los Angeles. Choosing a trust contest lawyer can be a difficult decision and an important one. At RMO Lawyers, we help people like you every day, and the consultation is always free. Reach out to us anytime at hello@rmolawyers.com. Thanks for watching.